All right, court is now in session. I believe the next case is Nintendo versus the United States of America. You, sir, are the plaintiff?
Yahoo! Here we go!
All right, and your name?
It's me, Mario!
And you are arguing that tariffs imposed by the United States under the International Emergency Economic Powers Act are unlawful in light of the Supreme Court decision seeking refunds of tariffs plus interest and fees, correct?
Okie dokie.
Objection!
What the hell was that? Sorry, force of habit. If I may, Your Honor, it's worth bringing into account Nintendo's long-standing history with litigations dating back as early as 1982. Nintendo has found themselves on various sides of the courtroom to truly mixed results. And while suing the entire United States may seem like a big chance, it is shocking how many times they have used legal means to attempt to have their way. And you are legal counsel for the defendant? Oh, no, I barely did enough years in college as is. I'm the video producer for Rant.
Oh no!
Oh yes. Let's start with the case brought towards Nintendo between 1982 and 1984. Universal Pictures claimed that Donkey Kong was a trademark infringement of King Kong, which was owned by Universal. And not only did Nintendo successfully show the key differences between a giant gorilla destroying New York City and a big ape fighting a carpenter with barrels and sentient fire, but Universal had previously successfully sued Arcade-O for the rights to make the 1975 King Kong remake, with the argument that King Kong was in the public domain. So Nintendo was the defendant and won. That doesn't really help any argument here.
Yahoo!
I'd argue it was Nintendo's first taste of the legal system, and their first taste for blood.
Oh no!
Case 2. Nintendo of America Inc. versus Blockbuster in the late 1980s. Nintendo did not like the fact that players were able to rent games, which meant Nintendo was not seeing any money for gameplay. Howard Lincoln even referred to it as commercial rape. What? Yeah, it wasn't great. But they had no actual legal course of action. So instead they focused on what they could attack. Blockbuster would photocopy game manuals and put them in the box because renters, admittedly like me, would steal manuals with regularity. Nintendo claimed that was copyright infringement. That seems almost petty. The courts thought so too, ruling in favor of Blockbuster with the caveat that Blockbuster had to also include their own third-party manuals as well. In the long run, I think history declared the true winner here. But things then fared a little better in the 90s when Nintendo sued Atari for circumventing the Lockout chip of the NES. Lockout chip? It was a piece of tech that only allowed Nintendo-authorized games to work on the system. Look, after the video game crash of '83, Nintendo took an extra measure to bring quality control to the industry, but instituted a licensing program that many developers felt was overreach and hurt their own revenue efforts. Turns out, Atari had gotten a hold of the Lockout chip source code under false pretenses, and the judge ruled that Atari would be denied the fair use exemption that would normally allow for this sort of thing to be done.
Yahoo!
As it turns out, Your Honor, the Lockout chip created a lot of controversy for Nintendo. Let's take a look at American Video Entertainment Inc. versus Nintendo, which was a $105 million antitrust suit that overlapped with the Atari case. Now, AVE claimed that Nintendo used its 80% monopoly at the time to violate US antitrust laws and keep companies out of the lucrative video game market. Unfortunately for them, without Nintendo revenue to keep them in the game, they shut down about a year later and the case was settled under a secrecy order.
Bye-bye!
Hey, let's not celebrate just yet, Mario. The next cases are against Galoob. What's a Galoob? Who? A toy manufacturer, in this case, the distributor of the famous cheat device, the Game Genie. Interestingly enough, Galoob preemptively sued Nintendo in May of 1990 to prevent the company from blocking their sales because at this point the reputation was already there. Nintendo then countered with their own suit looking to stop the sales and that it, quote, directly violated Nintendo's exclusive rights to create derivative works by creating the Game Genie and that Galoob was a contributory infringer by encouraging users to create derivative works every time they used the Game Genie. Courts weren't having it and ruled that the device did not create derivative works, but instead simply modified the current ones temporarily. Nintendo attempted to appeal the decision, which was denied, and then tried to appeal the $15 million in damages, but that was also denied as well. Okay, so there are a series of cases here, some as a defense and some as a plaintiff. Nintendo's a big company, it's not crazy they would protect themselves here. Well, I'd argue it's about being the arbiter of taste up at this point. The Atari era had a glut of games that ranged from great to awful, E.T. being the most famous at this point, and Nintendo wanted to keep that from happening again. The problem other companies had was, who is Nintendo to decide who can and can't be in the games industry? Now, from here on out, Nintendo goes on the attack, especially once the technology of copying games comes into play. There's more? Your Honor, we haven't even gotten out of the 90s yet. Nintendo of America Inc. versus Bung Enterprises Limited in 1999. Bung was a Hong Kong company that made devices which allowed you to back up your games. Nintendo had first tried to litigate retailers who sold the device in the US, which kinda worked. It turns out there was a severe shortage of official development hardware from Nintendo themselves, so devs started using Bung's hardware instead. Bung realized this, attempted to advertise themselves as this sort of workaround, and when Nintendo got wind, they got the stores to stop selling them. Nintendo then attempted to stop the sales in the UK on a technicality. Their power adapters weren't properly certified, but Bung then just certified the adapters and continued selling. So Nintendo went after Bung directly for trademark infringement and the applicability of the DMCA, which was instituted that prior year. That seems pretty fair if this device indeed allowed and nearly advertised circumventing the rules of the platform. Yeah, Bung's being pretty egregious here. They dissolved the company and reformed as First Union Technology instead, selling the exact same product under a new name and label which continued selling in the US until Nintendo had the products confiscated by US Customs. I assume they went out of business? No, they make vapes now. Next we have Leaksong, a retailer that sold mod chips for consoles to allow them to play unauthorized titles on systems. Nintendo was joined by Microsoft and Sony in alleging copyright infringement, and the courts granted injunctions preventing the retailer from selling these devices. After that, we have a pretty interesting one. Anescape Limited actually sued Nintendo for violating controller patents for the Wavebird wireless controller, GameCube controller, Wiimote, and others, which they initially won, but then Nintendo appealed and overturned the decision. Stop it. In the same vein, we have Creative Kingdoms, an amusement company claiming the Wiimote infringed on the patent of the magic wand they use in their LARPing attraction. LARPing? Sir, if I have to explain LARPing, we're gonna be here all day. Too late. Nintendo took on Mi Station and many other flashcard vendors for their ability to run pirated ROMs on Nintendo handhelds. Nintendo took on D-Storage, an operator of a file hosting site, for not removing copies of Nintendo games. They took on a load of UK internet service providers, forcing them to block access to certain Switch piracy and hacking sites. They attacked a go-kart rental service in Tokyo that used Mario costumes and branding to advertise IRL MarioKart in the streets. That feels like a pretty small operation for a conglomerate like Nintendo to go after. Not until you look up the number of Blue Shell-related deaths each year in Tokyo, which is 0. Nintendo filed and won cases against LoveRoms.com, LoveRetro.co, and ROM Universe, as well as individuals like Switch modder James Archbox Williams, who ran a shop that allowed games to be downloaded to jailbroken Switches. In what I can only describe as an act of poetic coincidence, Nintendo of America filed a lawsuit against a Canadian hacker, Gary, and I wish I was making this up, Bowser, who pleaded guilty for hacking and selling modified consoles and saw $4.5 million in forfeiture, $10 million in damages, and a 40-month prison sentence.
So long, Bowser!
Most recently, Nintendo used their legal prowess to shut down Yuzu, a Switch emulator they claim facilitated copyright infringement. Hold on. While copying ROMs is piracy, I do believe there is room for discussion when it comes to emulation, correct? True, but Nintendo never saw it that way. Truth is, Nintendo has far more money and resources than a project like Yuzu has, and so they settled with Yuzu shutting down its doors and us losing one more key towards game preservation. Okay, so Nintendo driving these lawsuits is not entirely unheard of. And I haven't even gotten to just general legal threats. The GameCube and Wii emulator Dolphin was at one point going to be released on Steam before Nintendo issued a DMCA to Valve, who honored it and canceled the release. And then, there are the fan games. Fan games?
Oh no!
Allow me to present Exhibit A, a giant scrolling wall of text. Okay, it's a lot, but it's well within their right to take down any project they please. I mean, sure, but this feels like a bit much, don't you think? Nintendo has some of the most popular IP in the world, with a fervent fan base. You'd think they want to celebrate that. I mean, this whole legal approach to IP protection is warranted in many of these cases, but I think back to when Sakurai was talking about Smash Ultimate and why Mai wasn't included as a cameo when they brought in Terry Bogard. He claimed that Super Smash Bros. Ultimate is for good boys and girls of many different ages, about a game that also features a playable Bayonetta. Sure, these aren't really family-friendly characters, but sometimes it feels like Nintendo is arbitrarily making decisions because they want the control. I mean, you know whose name I didn't bring up here? Wisdom Tree. an unlicensed developer that published Christian video games without Nintendo approval, using a voltage spike to short out the Lockout chip and bypass security. Nintendo never took legal action despite it being well within their right and track record to do so, likely due to fear from religious groups. A lot of the attacks on ROM sites, though legally warranted, seem more out of principle since most of the games are out of print and otherwise unavailable to access. It just feels a little extreme, and now they're going after the United States government over tariffs. Now, they aren't the only ones. Companies like Costco, FedEx, Dyson, and over 1,000 others are doing this, but Nintendo is the one making a splash from this industry. It's just worth noting that it's not surprising given their habitual use of the legal system. All right, do you have anything to say for yourself?
Mamma mia!
All right, bailiff, go after him. We have an actual case to settle.
Here I come.
As for you, are you done? Almost. Let us know if you like this video, and for more in the world of gaming, stay tuned to Game Rant. Who are you talking to?